Arbitrationagreements.org. Pre-arbitration is a term often used in legal circles, but not many people outside of that world are familiar with what it means. Before we dive into the meaning of pre-arbitration, please give us a like, hit the subscribe button, and tap the bell for notifications so you can keep up with crucial legal topics. Simply put, pre-arbitration refers to the period of time before an arbitration hearing actually takes place. During this time frame, the parties involved in the dispute can engage in negotiations or discussions in an attempt to resolve the issue before the arbitration process begins. This can involve a variety of approaches such as mediation or settlement conferences, in which a neutral third party tries to help the parties come to a mutually acceptable resolution. Pre-arbitration can also involve discovery, which is the process of gathering evidence and information relevant to the dispute. This can help each side better understand the position of the other and potentially facilitate a resolution. It is important to note that pre-arbitration is not always required, but it can be an effective way to avoid the time, expense, and uncertainty of a full arbitration hearing. By working through the issues beforehand, parties may be able to reach a resolution that satisfies everyone involved, saving time and money in the process. Do you need more information about the basics of pre-arbitration? If so, head on over arbitrationagreements.org. Now, our association does not provide any legal advice, but give us a call if you or your business are considering opening a new account or case. Also, what do you think about pre-arbitration? Does it sound like a potential solution to resolving a dispute? Give us your opinion by leaving a comment below. Don't forget to like, subscribe, and ring the bell for notifications so you can stay up to date about the world of alternative dispute resolution.